Good morning. Welcome to the National Association for Port Management's webinar, sponsored and presented by Tyler Technologies. Justice Reimagined, the Future of Courts After COVID. My name is Jeff Chappell. I am a member of NACOM's Board of Directors and serve as the chair for the Communications Committee. It is my pleasure to introduce our presenter, Brian McGrath. Brian McGrath is a leader with wide-ranging technology experience throughout the state and local government. He currently serves as a Senior Vice President of Operations in the Courts and Justice Division of Tyler, focusing on technology and services delivery to key stakeholders in the courts community. He serves as a Senior Vice President of Operations. Brian joined Tyler Technologies in 2004, and since that time has served as government leaders in multiple sectors as they transform their operations and technical capabilities. His most recent experiences centers on the implementation and adoption of electronic solutions for courts, attorneys, and pro se litigants. Before joining Tyler Technologies, Brian earned a Bachelor of Science degree in journalism from Texas A&M University. He currently resides in McKinney, Texas, with his wife and 3 children. Before we get started, I'd like to go over a few items so you know how to participate in today's event. This presentation will be approximately 60 minutes long, and we are recording today's webinar. The recording will be available after the presentation on NACOM's website. We also would like you to take a few moments to complete the brief survey after the webinar. If you're joining the webinar today on your computer, please submit your questions to Mr. McGrath through the presentation by typing your questions in the chat. I will address your question during the Q&A session at the end of the presentation. If you're attending the webinar by telephone, you may email your questions to nacom@nacomnet.org. After the webinar, and your questions will be answered. With that, I would like to turn it over to Mr. McGrath, and hopefully his sound is better than mine. I apologize.
Sounds great. How am I sounding, Jeff?
I think it sounds good.
Fantastic. Well, I appreciate that introduction, Jeff, and greetings, everybody. This is a rainy day here in Texas. As Jeff mentioned, my name is Brian McGrath from Tyler Technologies, and I really appreciate the opportunity to be with you today. In the last year and a half, when we think about justice and COVID, our vocabulary really has expanded. We've learned about things like contact tracing, social distancing, PPE, and I would even add, ironically enough, for our presentation today, even Zoom fatigue. And so just as we began to possibly move on from some of these implications and terms, we find them really all back at the forefront. So again, really appreciate the opportunity to be with you today. So technology capabilities really have always outpaced our policy making and really best practice development. And then, as I'm sure you've often found, when policies and best practices are formed, you start to run into this aversion to change that we and you as leaders have to overcome. And that is until that pain of not changing really begins to become greater than the pain of change itself. And it's really with this backdrop that I'm sure many of you are feeling some flavor of the same question. I get this on a routine basis. And that question is, what is our new normal? Well, in 2020, our justice system showed a resiliency and keen ability to adapt. And really, as part of that, there was a seismic shift in that willingness to change that I mentioned previously. No, the pandemic really didn't change anything about court responsibilities. It didn't change due process or really roles and parties and cases. What it did, though, was change expectations for what was possible, what's reasonable, and really what's acceptable for how that process plays out. And so it's clear now that once again, the bar has been raised. We've seen this time and time again, and here we are yet one more time. And just to reflect on that, as we look back, really 200 years ago, most of our systems within courts dealt with paper-based record keeping and then paper-based processing. It wasn't until roughly around 25 years ago that we saw more ubiquity of computer technology. Batch scanning became the norm, where case files were actually digitized and scanned so you could begin to work with electronic documents. it really wasn't until around 10 years ago or so that e-filing became adopted. And even when it did, it was done so in more of a limited basis. And even though it's 2021, just thinking back 5 years ago, that's really when we started to see across the country universal e-filing become the norm, especially under mandates when dealing with attorneys. So that's the type of change and the pace that it's moved with in our history. And so really naturally, if we look at that history and given what we've seen, the natural question now is, what specifically do the next 5 years look like? Again, going back to it, what is that new normal? That's the question I'm sure you're getting, and that's often the question posed to us as well. Now, to be honest, we've really come to resist that phrase of new normal, especially when it relates to technology. Really just the notion that we were at some sort of static point in time of normal, if you will, and that we're going to some new definable static point in time, in the future. It's really just a false view of reality. Instead, though, the notion of continuous change, that's what we have to acknowledge. And it just so happens that that change was recently accelerated and compressed in a short period of time over the last year and a half. So, a way of introduction, just if you aren't familiar with Tyler, we really appreciate a vantage point that I just want to share with you before we progress on. Tyler is the largest software company dedicated exclusively to the public sector. You can find us as an S&P 500 company. We've got offices all the way from California to Maine, and we support courts and other offices all over North America and around the globe. All we do is software and services for the public sector. We're organized into different portions of government that we serve, and my team, as Jeff mentioned earlier, focuses exclusively on courts and justice solutions. Now, most of you that are joining us today have some experience with Tyler, either in a direct or an indirect way, either through our courts offering in your professions or through one of our other offerings when state and local government, either as a citizen or a parent. My children get onto a bus and I know exactly where they're at via Tyler systems, and having to do that because school just started up. So some way, somehow you've probably interacted with Tyler over the years. Now, we support more than 213,000 public sector employees, you, your peers, and many others who rely on our software to do their jobs. And that's more than 27,000 installations of our solutions really across over 1,000 different agencies in the country. And if we look specifically at courts, again, just our unique vantage point is we've been serving this market now for about 35 years. And over that time, upwards of 55% of the population is served by some flavor of our courts and justice solutions. And so naturally, we look at the justice system, given that purview and that breadth, we look at the justice system through the lens of technology. That's what we do as software providers. And so really, as part of framing our time together, I want to review some of the realities of technology change in the last 10 years that brought us to this unique point in time. Again, this time where we are seeing really compressed change. So again, to reflect and just kind of share some of our vantage point, I thought some of these were interesting just as a backdrop before we explore deeper into courts. Technology at this stage is everywhere. That's no surprise, but it's interesting just to see some of the stats. In many countries around the globe, cell phones are actually more common than computers at this stage. Today, almost 9 out of 10 people own a smartphone, and that's just compared to 30% from 10 years ago. We've seen that communication transform really from perhaps some static audio, very limited audio capabilities, all the way to a full digital audiovisual experience in the palm of our hands. Now, what we've seen is a lot of good that comes from these advances. For example, just the ubiquity of cell phones and video communication. Even over the course of the pandemic, Tyler provided more than 40 million free minutes of communication to inmates and their families and their friends during the pandemic. We know how crucial staying connected is when someone is incarcerated, and I'm sure you've seen too that can even lead to a reduction in recidivism rates after their release. And inmates are now able to join birthday parties and even attend job interviews while they are incarcerated. So obviously more common, but then definitely has tremendous benefits for us. We've also seen collectively a major shift in commerce and the exchange of money over time, whether it's just paper-based money all the way up to mobile-based payments and beyond. Now, what a few things I thought were interesting. I looked this up just to verify it because in some instances you would think this was a lot, and some you might say, hey, that doesn't seem like enough. But now, about 1 in 7 of every transactions occurs via e-commerce on the web as opposed to traditional brick and mortar stores. So that's about 5 times higher than what it was even 15 years ago. And in courts, what Tyler's observed is about a 22% increase in payments simply by sending things like text reminders. And so you combine that mobile technology now with new forms of communication. We're really starting to see the benefit there, or new forms of commerce, I should say. Lastly, just as we've also seen major shifts in communication, we've also seen something very similar in computing, from really enormous servers that took up large rooms. I remember working with punch cards many, many years ago, to systems that operate on now redundant, almost nameless cloud-hosted servers. And so what we've seen in this, just in our conversation with courts, is now about 2 out of every 3 jurisdictions is considering migrating their systems over to some form of a cloud-hosted solution. So that's technology change that we've experienced in recent history. And in addition to that, the adaptations that you all have made as part of the pandemic really have forever changed the expectations of everybody that's involved. If you think about the general public, not only do they have expectations from commercial applications outside of government, but they're now able to better participate in the justice processes, since you have brought your systems now more online through tools such as this and many others. And really what we're starting to see is both the public and courts are benefiting. Further, legal professionals, they continue to see electronic filing expand. The solutions being offered to that particular community are also growing beyond electronic filing, with more options for just online case access, moving into scheduling, and even researching newer cases and other matters as they arise. And further, the judiciary at this point, we think is forever changed. You know, we sent a poll out to several senior judges and court executives last fall, and we asked, over a myriad of changes that have been implemented throughout the pandemic, which of those adaptations do we think had long-term staying power? Which ones do we think would be permanent? And there were several that bubbled up to the top of the list, 3 of which are shown here on your screen. But 100% of respondents said that alternatives to in-court procedures would be permanent. So combining these together, we really find ourselves amidst rapid changes in technology with a host of new capabilities, all of that coupled with rapid changes in expectations amongst court participants who are now accepting of more experimentation. Now, we've yet to find that elusive new normal. The solutions that leverage these technologies still need a bit of maturity, and we still need generally accepted best practices as they're employed, unless we find ourselves attending remote sessions. I'm sure many of you have seen a particular attorney that happened to be in my home state of Texas that ended up attending a session as a cat. So that's not necessarily something that we want to reproduce. So to generate that maturity and those set of best practices, rather than talk about that new normal, I contend that we should not concentrate on specific solutions, but it's more important for us to condense our focus down to the qualities that we're seeking to influence, more outcomes, if you will. That'll provide us the measurements that we need to facilitate progress, and it'll yield much greater outcomes than seeking just the attainment of that so-called future state or a defined new normal, if you will. Now, I've seen members of this particular audience drive outcomes at all manner of scale and category. The most impactful outcomes, though, I think we can really distill down into these 3, and it's when you set your sights on access to justice, speed of justice, and agility of justice. Those 3 are common and something we've seen time and time again. When this group focuses on those, then great things happen. So rather than paint a specific picture of that future state, with the remainder of our time together, what I'd really like to use is, use these outcomes as lenses to just condense that focus. And so to assist with that, let's look at a few specific examples. So let's start with access to justice. And in doing so, I'd like to examine just a few examples, namely with remote court proceedings. So for years, courts across the country have valiantly tried to put systems together that improve efficiency, connectivity, and even convenience. And as I've mentioned before, technology changes quickly. And as that changes, we've all found ourselves trying to find the best possible solutions for things like case management, video conferencing, online payments, notifications, e-filing, document management, and many more. And what happens is over time, what we have seen even firsthand, as these are procured in targeted instances over time, that can create this sort of spider web effect that are well intended to make things better for the court, but really is something that is becomes perhaps unmanageable over time. And what we see is that I believe we can all do much better than sort of this splintered spider web effect, if you will, and really just have an opportunity now to kind of unravel that web with an all-in-one solution that brings all of these tools together. So one specific example of that that we've seen as a vendor, we've really felt a responsibility to push the envelope here, especially with respect to things like integration and connectivity. And recently we've done that with a solution that we call Virtual Court. There are other solutions that are available, just use this as an example. I just want to share with you some of the ideas that we've had along the way about what you could expect in a consolidated tool. So first and foremost for us, we think a solution like this needs to be purpose-built for the justice system. We've used a lot of tools that we've seen like Zoom and others that don't necessarily integrate. We think tools like this should definitely integrate with your back office systems and allow you to log in really from anywhere with an internet connection. I think judges should be able to see pertinent case data on screen in real time. That requires that integration that I spoke to, and really be able to interact with case parties in a very natural way, something that's facilitated just as though they were physically present in a courtroom. And lastly, we think that court clerks and staff should be able to update case information from that same tool, things like generating orders, collecting signatures, going forward with business processes, general workflow, all while using one consolidated application. And of course, it should all be tied to the financial system so that you can also take fines and fees immediately and conveniently in the middle of that session without having to go out to disparate tools. So we can really recognize the impact of the pandemic having major impacts on court operations, and clients across the country have had to close their doors throughout the past year and a half. Solutions like Virtual Court, though, have really allowed folks to transition hearings to the web, and they've given defendants a way to safely speak to a judge about their cases. But the impacts really have been much more far-reaching than just sort of remote access. We've had clients, for example, that they have courthouses or their jurisdictions are close to major interstates, and they have a lot of citations that are given out to folks that are transient or actually moving through that locale. And so not just are we able to provide remote access for folks that are in that general geography, but they now have a convenient way for defendants to be able to resolve their cases. And those defendants don't have to incur hardship as they would typically have difficulty in making it down to the courthouse. Instead, they can just simply connect from home. So in thinking about the impact of that and how we might measure it, in some jurisdictions, because of the convenience been offered by tools like this, we've seen drops in failure to appear as much as 60%. I think earlier you saw a quote from Chief Justice Hecht in the state of Texas where comparable solutions have seen very similar results. And so really just the convenience of being able to log into a court session from just about anywhere is largely a game changer for defendants who likely would otherwise simply miss that pretty important date. So I'm sure you can appreciate the downstream effects that it has, not just on courts, but just defendants themselves, doing things like avoiding license suspension, additional fees that may come with it, and then perhaps possible arrest that clogs up the court system. And really with this, they're able to resolve matters in very short order. So where do we see this particular technology going? We think there's a lot more to come in this area. And we started with traffic. In particular, I know other jurisdictions have started their virtual processes with other case types. We chose traffic in working with our customer base. And we wanted to make sure that we could have a solution that managed the high volume, fast processing of cases that are inherent to these particular case types. It does that very well, in our opinion, really gave us a solid foundation for us to build upon more in the future. What we envision is that over time, we would add in processing and capabilities for all case types to be handled, especially those that are much more complex that require multiple parties and much more functionality. So we're building on this to handle many more case parties, adding things like sidebar, private rooms that folks can exit a session in, converse, and then rejoin, and even streamlining things like document management flow and adding in signature capabilities so that all of that can be facilitated online with an electronic tool. So this already lets you save video for a particular session for a court recording purposes, but we're also adding in things for us to be able to stream this online as well, just if the general public needs to observe. So biggest part of the vision for us here is just having that total connectivity and integration that I mentioned. And ultimately, when you think about access, that's really the heart of the matter for us. So then after talking about access, let's really think about speed of justice. I mentioned there were 3: access, and then moving on to speed. I really here would like to focus on enforcement and courts, law enforcement and courts partnering together just to really expedite the processes where they're coming together. And I want to do so with one particular example where we think about drunk driving and an officer that may come upon a particular scene that has to make quick judgment and take quick action in that particular matter. Now, all of us have long been about reducing things like injuries and fatalities from intoxicated motorists. That's long been a focus for this community, not just courts, but obviously law enforcement and then policymakers. And in this particular case, speed of the process really begins with that first contact of a member of law enforcement coming into contact with a motorist on the street. Now, in that particular scenario, there are around 3,000 to 4,000 DWI arrests every day across the United States. And there's a significant amount of time that law enforcement spends on the side of the road. That's a safety hazard. It's also very, very costly. And in about 20% of those instances where it's allowed in a particular state, that process can result in a blood draw warrant. And when that's needed, precious time is often wasted as officers have to work with a supervisor and then ultimately get to a judge for approval. And so that's time that an officer is not spending out doing other duties. And then obviously, if you just add this up over time, that's very, very expensive for our systems involved. Not only that is it expensive, not only are they not spending time in other matters of keeping us safe, but it's actually time is really of the essence in these particular instances. If you think about your blood alcohol content, it actually dissipates by 0.015% every 60 minutes or so. And so if you do not actually get a blood draw warrant, for example, approved in that time period, then the person in question, their blood alcohol level may actually drop below a legal limit. And so you're losing out on that valuable evidence that would be needed in order to prosecute. And that's especially a challenge if there's been harm that's been done in a particular scenario. So you can imagine the gravity of that situation and really where just saving an hour in this process is crucial, it's critical. So rather than some sort of lengthy process that involves multiple kind of paper-based handoffs that are in person, I mentioned kind of a handoff to a supervisor and then possibly to a judge, what we see is leveraging the power of cloud-based solutions that really cut that time in half or perhaps more. This is just one example of many, many benefits, but what we see is that with a cloud-based solution, we've actually built an application called Electronic Warrants that allows for a law enforcement officer to look up a party, very quickly fill out a warrant and send it over to a supervisor and ultimately a judge for approval. That can be streamlined into a queue, something that somebody can electronically sign, that really we can get that process cut down very, very quickly. So it's just one example when I talk about speed, how we can partner together between law enforcement and courts. There's many other examples, just wanted to use that as a good proxy for us. So we talked about access, we talked about speed. The third thing that I just wanted to talk about is how we drive agility within our court system. How do we operate with agility? And really to do so, I want to talk about what we consider to be probably the most hidden but valuable asset that courts have, and that's data. I know every one of you is looking for ways to use data to innovate, see it on a routine basis, but oftentimes see folks running into challenges in trying to extract that value. So First, the data often exists in silos between really just disconnected systems. Even in a system like a case management application, case events and statuses are used differently in different case types. That's often for very good reason. But rationalizing the data to try to understand where personnel might need to be better suited or where we might need to modify processes becomes really difficult even within a particular silo. We're also challenged just by getting access to data outside of things like standard reports. Those things can be fairly long, and it can be a pretty difficult process. I know anyone that's worked in courts has spent many hours just working with reports, reports to outside agencies, reports that are internal, many of which are outdated. Those standard reports have the fatal flaw of kind of this rigidity, if you will, that keeps court administrators from really being able to answer things like ad hoc questions from policymakers, different justice partners, different funding bodies, or just to use them for internal management and innovation purposes, like being able to make a quick decision based on what you're seeing. So historically, there have been some organizations that have tackled these challenges, but oftentimes they were really only the largest agencies that had the funds and the means to produce data programs that could get them meaningful insights. Oftentimes, though, those were even unique projects that really didn't translate well to other agencies. And so we think agility in this instance means repeatable, flexible solutions that all courts can use. Now, there's a lot of tough issues that we see many of you addressing and that we assist with, but the focus lately has been on two primary questions that I think many of us are trying to seek the answer for, especially when it relates to leveraging data and agility. First is, how can I quickly reduce my case backlog and predict what case types will surge in filings? In many instances, we're seeing unprecedented case backlogs in certain case types. And I know many of you are expecting some form of a surge as we continue to open up. And then there's certain temporary rules. I think of things like moratoriums on evictions, for example. We're not quite sure when things like that would be lifted, and we're just not quite sure what that's going to do to filing volume and case backlogs when those do occur. So that's the first major question. The second major question that we see quite often is, what changes that we have made to case processing have shortened the critical path from filing all the way to disposition. Many courts made shifts to their procedures during the pandemic. A lot of times that resulted in greater efficiencies, but it's really difficult now to measure what some of the unintended consequences might be of some of these new processes, and really just to continue to identify new opportunities for change. So those are two common questions that we see courts trying to navigate today. I wanted to share with you, I know there's a myriad of options or ways that you could tackle these. I just wanted to share with you what one particular statewide judicial branch is doing as they think about these questions and have a vision for maintaining agility, leveraging data. Historically, this particular office struggled quite a bit to collect data amongst all of the counties that are within their purview and really trying to standardize it. And so their vision now is to standardize that data with a constant sort of real-time feed, if you will, on an enterprise data platform. They're providing local and statewide access to that data, mostly through targeted applications. I'll show you a few examples of that here in a second. And from there, they're standing up repeatable processes within each court so that they can work within the local agency and at the statewide level to coordinate and then respond to things that are happening real time. So just to give you a sense for that, they're doing all of this really by starting with the performance of their electronic filing system. And a lot of this is just tracking incoming cases by case type, case category, and the fees that are coming through. Supervisors are monitoring internal staff just to make sure that perhaps if those staff members are remote from the court, that they're processing things timely through their systems. They're gaining insight into filing patterns. This is particularly important with self-represented litigants. In a lot of case types, we're seeing a large increase, and I'm sure you are as well, of self-represented litigants filing things, particularly in family matters. And so they're looking at those patterns to try to respond appropriately. And they're also allowing each user to create things like their own dashboards and sharing those dashboards, just creating custom metrics and measurements that are unique to them, all as part of this sort of initiating process, if you will. Moving on into courts, from there, they're seeking to replace and really just modernize their overall state reporting structure. For them, what they're envisioning is that that'll eliminate possibly thousands of hours of manual data cleanup and formatting that occurs year in and year out. And it's starting to surface data to people who are working within the system in a really accessible, easy to use interface. So if we think about all that time that's traditionally spent knitting together this data, with a time savings, they're actually asking folks, instead of cleaning up data, to leverage that data to actually make policy decisions and start to explore some of these cause and effect relationships between different modifications that they might to their policies, procedures, or even business processes throughout the justice system, and able to really just facilitate communication of what they're finding at all different levels. From there, they're really starting to focus now on more downstream effects and starting to create new reporting structures that are in areas that hadn't been previously aggregated. And this is namely around things like pretrial and in probation, supervised release, if you will, or adult probation. So they're embarking here just on taking that data where it previously was in these silos and holding it at the statewide level, and really just allows them to more easily track performance metrics and evaluate the policies and what their impacts are. If they've made different reforms, what the impacts might be to things like recidivism rates or certain programs being more effective, et cetera. So I think you'll all agree this is really, really powerful. And the initial point, thinking about electronic filing in courts, we can look at efficiency, but then think about the agility that it affords you if you're able to actually see what those downstream effects are and able to go back to the beginning of the process to make changes that have those downstream impacts. So really, just as we review, I mentioned this at the top, I really don't think we're marching towards some form of a new normal. I really think this is more about seizing what we might term a new window of opportunity. When you think about things like emerging technologies, when you think about emerging expectations or evolved expectations from participant, the question really becomes, what can we do to take advantage of this unique moment? And so with that, I really encourage everyone that's joining us today, just take a step back, review your strategies, particularly through the lenses of access, speed, and agility, and be inspired by your peers, because there really is a host of great thinking that's out there. So I very much appreciate your time today. If you'd like more information from Tyler, you can scan the QR code that you see on the screen before you. Feel free to contact us on the web. I really appreciate your time, and I'll now turn it back over to Jeff. I believe we might have some time for a bit of Q&A. Yep.
Thank you, Brian. I appreciate that. Hopefully my audio is improved in the last half hour. Great information. Anybody that has questions, please put them in the question and answer, and we will be reading those to Brian. First one is, what can Tyler offer courts in terms of redaction capabilities?
Great. Redaction, we've seen quite a bit of uptick there. We have two different solutions at Tyler for this. One is embedded in our electronic filing application. The other is embedded in our case management systems. You can use that capability independently, so one, the other, or both. In terms of redaction, there's a capability, there's a manual capability that's long existed for attorneys to manually strike through certain items. But in addition to that, what we all know is that automation wins the day there. So we have the ability, when a document is uploaded in our electronic filing solutions, to run that through a redaction engine. That is actually being strengthened right now. Today, it's looking at what we would term PII, or just the personally identifiable information, social security numbers, things like credit cards. We're actually expanding that now to be integrated in with case management platforms so that we can look at private data like names, in particular, look at juvenile names within a document. We can do that with case management data, but we can also take context clues from documents themselves and be able to redact juvenile names, like when you see things like child and other different data elements and documents. So that technology is being employed within our electronic filing systems. At the time that a document's being uploaded by an attorney, we can ingest that in and run it through that redaction engine. then we send over a redacted version in the original to the courts so that you could display perhaps a redacted version in an online tool if you needed to make that available. We also have that exact same technology and engine available if you have perhaps a historic document and you find that within a case record and you want to send that through the same redaction engine, you can do so. Or if you've uploaded something in the case management system that came through a different channel, you can run it through that same system as well. So same technology, just employable in those two different instances. Great question.
Next question is, when will signatures be available for virtual court?
I'd have to double check right now. I believe we're targeting the end of the year, but I'd love to go back and just double check that because I want to make sure that I don't completely misspeak there. Mainly by the end of this year, the major things we wanted to get done were facilitating multiple parties to be added. If you think about traffic, we started with sort of one party, one defendant, if you will, plus a clerk and a judge. We're adding in multiple parties, and I believe that's on the schedule to be completed by the end of this year. But if I'm telling you wrong, I'll respond back to the folks and let you know.
Great. Are you able to help courts demonstrate cost savings efficiencies by using technologies so that the government funders are persuaded to fund virtual solutions?
Yeah, so I'll leverage a couple of examples there. What we've largely seen that done is on our data platforms, where we can look at things like measuring all the way from case initiation through perhaps hearings being created and the disposition of a case, and taking that timetable and being able to measure that over a span of months, years, et cetera. So when I showed briefly some of those data solutions, what you're able to do when you take that case information is really show it on a timeline. You can look back at key moments where you've initiated new policies, new business processes even. So perhaps, hey, at this point in time, we went to a virtual offering, and here's what that did to our time to disposition across our different case types. From there, you can even take some of those learnings and do some what-if scenarios to say, hey, based on some of those assumptions, what might be our time to disposition moving ahead if we were to modify additional policies. You can put some key assumptions within there. And so that really allows you over a wide array of time to say, here's where we were prior to roughly March 2020. Here around April is around where most courts shut down, April of 2020. Around June, July, August of 2020 is where most jurisdictions started to institute more virtual offerings and remote offerings. Here's that time to disposition across targeted case types in those areas. And then here too would be additional savings that we might see in, again, I'm going on time, that we might see moving ahead based on the following assumptions. Given those, I know many of you are facing budget cuts. Some of you are actually seeing increased funding through federal grants. And so what you can do is translate that time, make certain assumptions based on cost. People costs are typically the highest area. Translate those people costs for savings, either in that targeted period or on into the future. And those are very much conversations that are happening today. So all of that is what we see within our data platforms. I know there's other ways that you can do that as well. I would mention one other thing. Court Tools has metrics around things like your staffing levels, particularly payment and other areas. And so that Court Insight solution, I didn't go deep into it, but if you're interested in more, that leverages the Court Tools metrics, of which funding and staffing financials are one key part. That's built into that particular utility and something we'd be happy to expand on.
Great, Brian. I've got a question from one of our attendees, Andrew Clark, asking, as more judges are now embracing working digitally, what strategies and tools do you have specifically focused on judges and how they work?
Yeah, judges, I'm going to paint with a very broad brush. And I'm going to use words that have been said to me. So if you repeat these and say that Brian said this stuff, then I will deny it, because it's only things that have been said to me. When I speak to like elected officials and clerks, what they have traditionally said is, and I'm going back over about a 15, 20-year time horizon, is that there was an aversion to technology from the bench. going back 20, 25 years. With electronic filing and more electronic systems coming into courts, what we're seeing is more adoption to electronic tools on the bench. Judges have taken advantage of that in chambers. They've taken advantage of that on the bench. Tyler produced an application specifically for judges that took our case management system and created a streamlined view just for judges to use in chambers and on the bench. We released that application around 2010, 2011 or so. And there wasn't broad adoption initially, but there were a few early adopters amongst the bench. And what we saw over time is that as they began to use it, they no longer wanted that sort of simplified, streamlined view. They wanted more, and often cases a lot more. And what they ended up wanting was actually the full breadth and depth of what we offered within a case management platform. And so now, again, painting with a broad brush, I see largely judges leaning into technology, taking advantage of some of the things even afforded to us by the pandemic to make major policy changes, instituting rules within their courts, and then adopting more. And so what we're actually focusing on now is, rather than offering that specific, more tailored solution for a judge that is just a standalone application, actually merging all of that functionality back into our case management system, so that if a judge wants a more simplified view, they can still get it, see their sessions calendars, private notes, etc. But should they and when they want more depth and more breadth, then they have the case management platform available to them if they want to expand out from there. So we used to offer a standalone application, continue to do that. We'll continue to support that, but just because of the appetite for more that we've really seen largely from the bench, we're actually merging those capabilities in with our core case management platform, still providing some specificity, a lot of that specificity there, but now bringing a lot more of the breadth that we offer in some other areas.
Great, Brian. We have a couple more. Next question was, how would you advise that they incorporate Tyler technology and tools in the areas of probate proceedings?
Probate proceedings, I think the straightforward, our traditional installation would be to make sure that we offer a case management platform such that your records can be housed in an official record keeping system. Again, I'm speaking selfishly on behalf of Tyler and our case management platform. We are not differentiating case type by case type, if you will, in tools like virtual court, in tools like some of our court insights. Instead, those are being employed across multiple case types. For things like probate, we do see pro se litigants embarking on certain solutions there, not as much as family or even traffic, but we do see pro se litigants working there. So that might be where you would employ something like Guide and File, for example, which is an online tool that allows somebody to either initiate a case or file into a case by filling out an interview, that producing the appropriate forms and that being filed into that case type. So there's a myriad of tools that I could see, from case management to even virtual court to some of the online solutions for the general public. But outside of that, there's currently not a specific thing that I would tell you as, hey, this is just probate and probate only, aside from those the broader use case tools I mentioned.
Does Tyler have a plan in the future for online magistration?
Yes. So in terms of magistration, a lot of times that's done using a case management platform today. What we are just now launching is one sliver of what you might consider to be that broad sort of digital evidence ecosystem that exists between law enforcement, prosecutors, the courts, and defense counsel and beyond. And that really just starts with electronic discovery. What we are just now launching is a standalone web application that allows law enforcement officers to upload digital media, so things like body cam footage, photos, files, etc., that can be passed over to a prosecutor electronically, all converted into standardized file types. From there, a prosecutor can bundle that information up and share that out with defense counsel. And so all of that really is that electronic discovery portion, that's that handoff with evidence from law enforcement over to prosecutors and then sharing with defense counsel. From there, defense counsel can upload evidence and that can go back to the prosecutors. The next portion of that is in things like electronic magistration that can be done outside of our case management platform, something that we'll be working on really in 2022, such that you could continue to use our case management platform for things like that, but we'll also be building a sister set of applications to electronic discovery so that you can do electronic magistration independent of a case management system as well. So it's a focus for us. We want to focus on getting electronic discovery right, though, first. So we're just now launching that. But that's very much a direction that we'll be moving in the very near future.
Great. Obviously, just a reminder for those, if you have any questions, we do still have a little bit of time left. Please toss them in the chat or the Q&A, and we can definitely get those over to Brian to hear a little bit more. What options do you have for a DocuSign style form with your system?
So when I hear DocuSign, I think electronic signatures.
Yeah.
Electronic signatures that exist in all manner of applications. So there's not necessarily one unique application that is just for electronic signatures that exists in things like proposed orders between attorneys and judges, that exists in, I mentioned electronic warrants. That warrant has to be signed when it's approved. There are a host of business processes within a case management platform that has to be leveraged as different things are routed between a judge or are passed back and forth. So there's not one particular solution that I would mention other than a host of capabilities throughout the breadth of the court's ecosystem. There are things that we are exploring, some of which are a little more emerging that I won't go into too much detail on, but that would be a little more independent of the current offerings that we have today. There are a few scenarios. One that we've mentioned previously that I don't mind talking about, things like just hallway plea agreements, things that occur there that are very manual and very tough to replicate in a remote environment. And so those are things that that we're currently exploring as independent capabilities to bring to bear. Happy to talk about that further in the future as things emerge. But aside from that, there's a host of electronic signature and digital signature capabilities that we have built into our workflow engines, our forms engines, electronic filing, talking back and forth with case management, et cetera.
Well, I do want to thank everyone for participating in today's webinar. I do want to take a couple quick moments to share a few announcements. Obviously, we want to mark your calendars to save the dates for the 2 upcoming conferences. We are focused on a in-person again, as we just had our in-person one in California. So 2022, we'll kick it off mid-year in Bellevue, Washington, February 20th to the 22nd. Details and registrations will be on the website soon. And then the annual conference saved for July 10th through the 14th in Milwaukee. That is also known as the Small Chicago. So great little town up there. And it shouldn't be near as hot as many of our other previous conferences. With that, I also want to talk, if you are joining us and you are not a NACOM member, please take a moment to visit our website, look at the great opportunities. We encourage you to consider joining NACOM. It's the largest organization of court management professionals in the world. In addition to providing the education at the conferences, with the membership, you'll also have access to podcasts, webinars, publications, guides, and other materials that inform members of the best practices, innovations, and uses affecting courts today. NACOM also provides a forum for working with other colleagues in the profession to improve the administration of justice. So consider joining at nacomnet.org. Further information about NACOM can be found at nacomnet.org. And further information about Tyler Technologies can be found at tylertech.com. A recording of today's webinar will be available on the NACOM website here in the future. But on behalf of the National Association for Court Management and Tyler Technologies, I would like to thank you all for joining us today. And again, thank you, Brian, for your great presentation, and Tyler for sponsoring today's webinar.
Sure, thank you. Thank you.